What are some tips for drafting a right to disconnect policy? My name is Ron Minken, and I'm a lawyer with Minken Employment Lawyers. Here are our top 10 tips, also known as the TTT, for drafting a right to disconnect policy. Number 1, state that the policy is with respect to disconnecting from work. This is the key, as it is required by the Employment Standards Act 2000. Number 2, set separate requirements for different categories of employees. For example, upper management, middle management, lower management, and other categories within the company. The different requirements will really depend on their level of responsibility. Certainly, upper management will be treated differently than employees performing administrative tasks. Number 3, explain how the policy will be enforced. It is always important for employees to be aware of how the employer will be implementing the policy, how the policy will be monitored, and also the consequences for a breach of the policy. Number 4, have employees set out-of-office notifications when their shift ends. This is a practical solution that employers may wish to consider to allow employees the opportunity to let others know that they are unavailable after hours. Number 5, carve out an option for flex hours. Many employees may currently be enjoying flex hours, meaning they can start work later or take an hour off in the day to pick up their children from school and then make up the time afterwards. Number 6, carve out an option for overtime hours. Many employees may currently be receiving overtime pay and may be relying on this as part of their annual income. Number 7, designate a person to whom employees can direct their questions and concerns. Number 8, outline expectations regarding responding to communications after core business hours, responding to communications based on who the communications are from, such as clients, customers, colleagues, managers, and responding to communications based on the urgency of the matter. 9, clearly communicate and educate employees. And finally, 10, get advice from an employment lawyer with respect to drafting the policy. Given the large discretion employers have in drafting this policy, they'll want to be very careful that their policy does not breach any of the other Employment Standards Act provisions, such as the limit on hours of work. We strongly recommend employers get advice from an experienced employment lawyer prior to the June 2nd, 2022 deadline. Tune in next time where we discuss more on the right to disconnect policy. Thanks so much for tuning in to Minken Employment Lawyers. If anything that we spoke about today sounds like something you are dealing with, please contact myself or one of our other experienced lawyers at Minken Employment Lawyers. We'd be happy to assist. Please go to our website and check out our employer guides, blog posts, and articles. Also our newsletter. Be sure to sign up.